Alrighty. Well, I think we might get started, everyone. Thanks for joining us here on a lovely Wednesday morning. I'm joined here today with Matt Bryan, a special counsel, and my name's Hamish Geddes. I'm a director here at Morrissey Law. Today we're going to be running you through what was initially planned, which is security of payments and what's happening in relation to the construction pause. But obviously, for those that are not aware, and many of you are, the government released some fairly significant guidelines yesterday in relation to how projects that are within the New South Wales government ecosystem are going to work over the next 2 weeks. And so we thought we'd take that opportunity to jump in and run through those today briefly, just so we can outline them and let you all know exactly sort of what we think about them. So I'll jump straight into that, and basically what are the changes since Monday, and this has been a big one for the construction industry, is the release of these guidelines. In our view, they're obviously very constructive, so that's great. They were released yesterday, and they apply to all jobs that are New South Wales government jobs. That's New South Wales Infrastructure, New South Wales Health, all the relevant agencies that may be delivering a construction project at this stage that are impacted by the construction site shutdown. So they're the two key things that you need to consider in relation to whether they are whether these guidelines are applicable. Is that they need to be, obviously the principal needs to be a government agency and a New South Wales government agency, and the project on which it is on needs to have a construction site that has been shut down. So for that purpose, obviously those construction sites are within the Greater Sydney area at this time. They've outlined a few of the key objectives that are within those guidelines, but look, simply the guidelines that they wanted to focus on is that the government's been made aware by relevant industry bodies that you can't just shut down a construction industry for 2 weeks and then tell it can start back up on the 31st of July and go gung-ho from that point in time. There needs to be a lot of work done in the background to ensure that when that 31st of July time comes around, that those sites can be brought back to life and works can commence as quickly as possible. What they didn't want is obviously for the 31st of July to come around, people came back on site, worked out what they're doing for the next week or two, and then finally get contractors back on board. So they've essentially created a set of guidelines that says this is what we want to do. And what they have done in relation to those guidelines is they have said if you're working on these sites, and they also may apply to state-owned corporation sites such as Hunter Water, Essential Energy. If you're working on those projects, you are able to continue to work and claim the costs that will allow you to be ready to go on the 31st of July. So that's a key change, because obviously those costs will be something you'll be able to claim from government. There's a couple of key things that are in relation to those costs. That obviously doesn't mean you can't have everyone who would be working on that construction site continuing to work. You do need to look at ways to mitigate your costs and losses, and that includes time and how that will work in relation to that. So you need to be looking at the ways you can mitigate your losses, but where you are mitigating your losses and you are in a position where you're getting ready to be able to go live on the 31st of July, those costs, without profit, but those costs should be claimable from the New South Wales government agency or the head contractor or the subcontractor under which you are engaged with. So that's certainly a big change. There's a couple of things that need to be live there for the 31st of July. There's a new COVID safe plan rules that need to be implemented. There's a COVID safe plan template on the New South Wales government website, which we'll share later as well. And there's certainly something to go and have a look at. And you need to be programming and getting ready for not only going live with as many suppliers and people on site in a COVID safe way on the 31st of July, but reading through the guidelines, you may need to be allowing for an instruction to accelerate those works to catch up on these next 2 weeks. So, look, that's certainly it's certainly a positive. It's certainly a positive outcome, and something we're very happy that has been undertaken. So. And one of the last things, well, there's a couple of things that in relation to contractual relief. This is good news that they've waived the notice requirements in relation to those jobs, but only in relation to the construction pause delays that may be suffered. So that's really good. But interestingly, SOP still applies. Just in terms of payment as well, they also are going to be flexible in relation to making claims for payment in relation to the July payment claim. And what that means is that they'll probably be advocating and allowing partial claims of milestones that have not yet been reached on those projects to be claimed in the July payment claim, or for the full July payment claim to be paid, payment on account, to ensure that cash flow keeps going through the industry. They have clarified that SOP still applies. So obviously, if security of payment was something that you were using or looking to use over the next couple of weeks, if the project had reached that point, it still applies, and you will still have your obligations under security of payment, which means you need to put that claim in, and you'll need to issue a payment schedule if you dispute any part of that payment, if you are the person receiving that payment claim, which is great. So that leads us on to what today was mostly about, which is security of payment in the context of this construction pause. I'll just change this slide. So does it still apply? Yes, it does. It applies obviously to all contracts that are currently on foot. And one thing I just wanted to touch on here, depending on exactly who the people are listening, but for those that are in the residential building game, in particular those that are building houses for people that intend to live in them, security of payment now applies. That was legislation that was passed last year, and legislation that was brought into being and applicable for all contracts after the 1st of March 2020. Drag out in the home building context.
Sorry, Hamish, you froze there for the last 10 seconds of that bit.
Oh, sorry. All right. I just simply said it's good news for those, so that we can so that people in the residential building space can now apply the Security of Payment Act. So I'll let Matt run through some of the basics of SOP.
Thanks, Hamish. The thing I'll just point out at the outset is that we're still technically working with two versions of the Act. So for those who don't know, there was a reasonably big overhaul back in October 2019. So contracts that were entered into before that date still are working under the old scheme, the old reference date regime. Any contracts that have been entered into since that date, which is now becoming more the norm. It's obviously, as more time passes, there's less contracts that predate that key date. And what we were talking about today is the current version of the Act. The key criteria that you have to satisfy when you're making a payment claim under the Act in order to trigger your entitlement is to ensure that the construction work is properly identified. More often than not, it'll be obvious to the party on the other side what construction work is is being claimed, but generally speaking, the more detail that's provided in the payment claim about exactly what work is being claimed and what amounts are being claimed for it, the better. Particularly when you're moving on to the adjudication phase, if it gets that far. So that's the first thing. Identify the work. You need to indicate the amount, as I said, of the progress claim that is being claimed. So that's obviously key, is to give an indication to the other side exactly how much money you say is due and payable, so that they can then engage with that and provide a response. This is one of the differences between the current regime and the pre-October 2019 regime. You have to state that it's made under the Security of Payment Act. So generally, you'll see somewhere on invoices or claim documents the words, this is a payment claim for the purposes of Section 13 of the Building Construction Security of Payment Act. In terms of when the entitlement to make a claim arises, Section 13 of the Act says it's on and from the last day of the month, or if the contract provides for an earlier date, it's on and from that date. So it's important that that date comes around before any claim is issued. We still see from time to time mistakes being made because people think that that's, for example, a due date and they need to get in before that date. That's the date when the actual entitlement to make a claim under the Act arises. So if the contract says, for example, it's the 25th day, you have to wait until that day ticks over. Otherwise, if the contract's silent on it, it'll be the last day of the month. There's also, in the current version of the Act, clarification of an issue that did cause a lot of debate at one stage, and that is that on and from the date that the contract is terminated, that there's a right to issue a payment claim. So if the contract does come to an end for some reason, there's still an opportunity there to make a claim. And you see the last dot point there, the claim generally has to be made within 12 months of the work being carried out. So there is a limitation, but look, generally speaking, that doesn't cause much of an issue. Obviously, people generally are making claims on a monthly basis. There's a couple of other criteria
in relation to people just putting their the words again, the magic words again on payment claims.
Sorry, I just missed the first part of that. Sorry, mate.
Are you seeing that most people are just putting the magic words on all their payment claims now?
Yeah, and I think that's good practice. Whether or not you're trying to make a claim under the Act, or whether or not you think you have to include those words, there's no harm in doing that. And particularly now that it's back in as a requirement of the Act, it should just be common practice. Whether or not you intend to or need to go off to adjudication, I think. So there's a couple of other criteria I'll just address really briefly. The first thing is for any head contractors issuing payment claims, there has to be a supporting statement which sets out details of subcontracts and confirms that relevant amounts have been paid. So that's important. That won't necessarily, a failure to provide that won't necessarily invalidate the claim, but it is an offence under the Act. So it's important that requirement be adhered to. And the final thing is that while you can only issue one payment claim per month, either on the date that the contract states it can be issued or the last day of the month, you can reissue payment claims if you like. So, for example, if a claim was issued in June, it wasn't paid and it didn't, for whatever reason, go off to adjudication, that can be bundled into a July claim. And then, if there's an adjudication, it can be taken into account. So that's a basic sort of overview of what you need to do to ensure that your payment claim is valid, and that if there is some dispute, you can take it off to adjudication.
Yeah, I think that the payment claim structure is really important in the general sense, but also under the changes that were made yesterday, it's probably a good little point to touch on. And one of the guidelines indicates that any costs that are going to be incurred in the construction pause phase. So this is obviously on those sites where the guidelines are applicable. On that phase, you do actually need to separate out and clearly identify those costs that have been incurred in relation to that construction pause. So that's a key thing that needs to be done. In terms of, and I must admit, I'm considering this quite rapidly, but in terms where you've obviously got a reference date or under the contract in that may arise, our view is you would just be better off separating out the costs that would be incurred in relation to the construction pause separately to the costs that you would otherwise be claiming for under the contract. And you need to work through exactly how you'd be able to identify that, but that should be put in the single claim rather than having the potential that there are two payment claims made for the same date. All right, so we run on to payment schedules here, Matt?
Yeah, definitely. Once someone receives a valid payment claim under the Act, they have 10 business days then to consider that and to provide a payment schedule in response. The payment schedule needs to identify the claim to which it relates, so that the claimant knows that it's getting a response to that particular claim, and it needs to indicate the amount of the payment, if there is one, that the respondent proposes to make, which the Act refers to, as you can see on the screen, as the scheduled amount. Finally, if the scheduled amount is less than the amount that's actually being claimed, the respondent needs to set out the reasons why that's the case, so that the claimant then can make a decision about whether or not to go on to make an adjudication application. It essentially puts the goalposts in position, if you like, and sort of sets the scene for any future debate, in particular in the context of an adjudication.
Matt, what's your view in relation to, if you want to be telling someone via email or otherwise that they sent you an invoice and it's not in the form or the structure that needs to be made under the contract? What should someone that's filling out a payment schedule do in those circumstances?
Well, I think it's your opportunity to outline all of the reasons that you want to rely upon if you dispute the amount that's claimed. So you definitely need to take that opportunity, including because there's a section of the Act that says that if you don't raise an argument that you want to rely upon in your payment schedule, you can't go on to rely upon it in the context of any adjudication. So if you want to say that the claimant hasn't properly complied with the terms of the contract, or that the entitlement to payment hasn't arisen yet, or whatever the case may be, if there's any other reasons, including that the work hasn't properly been completed, that it's defective, whatever the reason is, it needs to be included in that payment schedule. And look, there's a lot of cases about what is sufficient to actually constitute a payment schedule. Again, as I mentioned with payment claims, that the more information you provide that ticks those boxes that are set out in the Act, the better. Generally speaking, a one-line email saying, I dispute this and I don't accept that there's any entitlement, isn't necessarily going to do the trick. You can't just sort of respond in really general terms. You have to say, as the Act requires, why it is. And that doesn't mean you have to write a novel and sort of set it out chapter and verse, but you need to give that indication to the other side of what your reasons are.
Yeah, absolutely. That includes I think one of the key things for everyone to understand is that a payment claim and a payment schedule are sort of like the claim and the defense before a court. And you've got to look at it from someone that has no idea about the context of what that dispute may be at that point in time. And so for us, the advice is always quite simple in that think of your payment schedule like your full defense. You may know exactly why you're not paying it, and the person that you're responding to might know exactly why you're not paying it. But rather than trying to have that creative argument in submissions during adjudication, it's easier to just point to exactly what you mean in a quite quick and easy way to respond in a payment schedule. And a payment schedule can be anything that responds to a payment claim in any way. So that's a key thing. If you respond in an email, for example, saying, "Hey mate, I need to review this and I'll get back to you," well, arguably that can be a payment schedule. It's better off to not get into those arguments and just keep it really clear. If you are going to dispute any amount, that you need to be outlining exactly what those amounts are. So on the next one, we wanted to talk about quickly about milestones. Now, some of this has been changed in the after these changes from last night, but milestones are an issue where obviously a lot of contracts and the ability for a reference date to arise accrues under a contract where a milestone does arise. With the two-week pause, that's obviously going to create a lot of issues. And we wanted to touch on this because it's a question that people have been asking us in various sectors. We've touched on it briefly in relation to the New South Wales government contracts, where they've clearly identified that they're going to be flexible in relation to partial claiming of milestones, but that needs to be outlined to them before you do it. It's not simply a matter of saying, here's a payment claim for 70%, thank you very much. It's that there is a requirement for you to collaborate and be open and transparent. So you should be outlining those to them before any payment claim would be made in relation to a percentage of a milestone. The same collaboration, though, I think exists in relation to any milestones that have been reached on a residential type projects or commercial projects that don't fall under the guidelines. People, are aware of what this construction industry pause is doing. Banks are aware of it, and so they're all coming on board to try and work out ways to get these things, to get cash continually moving through the projects. Milestones is obviously a significant issue now on residential projects where we've seen a supply pinch over the last couple of months in relation to significant works that often are attributed to a milestone. For example, frames and trusses is an easy example. They've been really hard to get on site. So if you haven't been able to make a milestone claim for that, but now you've actually had the frames and trusses delivered to site, but they're actually not entirely, erected at this stage. Our view is to have a conversation with both the owner and the bank in relation to seeking payment for those amounts during the construction pause. It's hopefully a fairly collaborative conversation, but it's a matter of just saying, look, I know that the milestone is when the frames and trusses are fully erected. We've got half of it up. Can we get half of the payment now? And banks are being, from what we've heard, banks have been open to undertaking that and doing that. The way you're having to validate that is obviously if they're not able to get on site with a QS to validate that, you'll need to work out a different way. But again, that'd be about talking to the owner and talking to the bank about how you can get that those funds coming through. So that's in relation to the milestones. We wanted to quickly touch on some of the specifics in relation to the various contracts that are out there. Look, some of these are very general, and I guess all this, this entire this entire webinar is actually general and it's not legal advice, so we have to give that disclaimer. But what we wanted to touch on are some of the common things. So here we're looking at how to make these claims under the Australia AS 4000. This one would be an unamended one, which admittedly we haven't seen for many years. There's not too many of them circulating. So under the AS 4000, you can make that claim under clause 37 for the payment claim. You're actually able to make an early claim in those circumstances if it's unamended. So an early claim is deemed to be on that later date. But in saying that, the clause 37 entitles you to a claim, but it refers back up to the ability to make that claim under the definitions, which includes a requirement under various items that are within the schedule. So you do have to go back and have a look at what your contract requires you to do. And also wanted to touch on quickly in relation to force majeure and what that means in the context of being paid. And obviously, force majeure is a question that has been asked of us, particularly in the last couple of weeks, last couple of days, and certainly something that is something to approach very cautiously. And why it's something to approach cautiously is it can suspend all rights under a contract, which can include obviously the suspension of your right to payment. So going down the force majeure path and whether it is now open to you is something that is certainly should be taken very cautiously and needs to be discussed with any of your advisors or someone that's fully across the way that the contract works and the rights and obligations that will flow and the risks that will flow from undertaking that path. So that's the unamended AS 4000. There probably are not too many people out there working under an unamended AS 4000, but there are your opportunities there, and obviously the ability to lodge a payment claim still exists. Wanted to quickly touch on the Master Builders Suite, the BC4 and BC3. This one's got some, obviously is very contractor friendly, and it's certainly a contract that we recommend to many of our clients. But the BC4 and the BC3 enables you to claim a milestone if 95% of that milestone has been completed. So if you can make an argument that has been done, that milestone should arise and you should be able to still claim during this construction pause. You can claim variation works at any point in time. So that is something that everyone should be aware of, particularly those in a construction pause. Now, they should be looking at their contracts, see what variations have or have not arisen, but particularly which ones have arisen, and know that they can actually claim that outside of making that claim at the point of a milestone. So the ability to claim a variation doesn't arise at the point of a milestone. Also, you can check out your opportunities for claiming delay costs. Now, I guess the MBA BC4 is a very contractor-friendly contract in terms of under this construction pause, builders would be entitled to claim for delay costs under the contract against the owners. Now, the delay cost is often an amount that is a liquidated amount, and they've got it in there of a certain dollars per day. So you need to look at that basis. And this is an example why a part of our advice often in for our clients in relation to this is not to have the liquidated damages amount and the delay damages amount to be the same amount, because they just change. They just very rarely are the same amount, and contractors in particular should give consideration to what their actual delay costs may be. So certainly something to look at and have a look at your contract if you're operating under the MBA suite. So Mate, you want to run through the HIA one?
Yeah, definitely. The HIA one, clause 19, and I'm talking in particular about the contract for new dwellings, but they all have similar terminology, entitles the builder to suspend for reasons that are beyond the control of the builder, and that includes things like an act of God, fire, explosion, earthquake, variations, disputes, things like that. It doesn't specifically refer to pandemics, things like that, but I think quite clearly that would be something beyond the control of the builder. I think the issue that is going to arise, though, is in relation to 19.4, which is the clause that potentially gives the builder the right to claim delay damages as a consequence of any suspension or extension of time. And it provides that those costs will only be able to be claimed where there's an act, default, or omission of the owner. So it may be that the way that is framed, subject to any special conditions that builders have in place, might make it difficult for the cost of delays to be recovered from owners in those circumstances. And I think, as Hamish said before, it might just be a situation where there needs to be some dialogue, not only with the owner, but potentially with a bank or a financier, just to see whether it's possible for an agreement to be reached in relation to these cash flow issues that may be caused as a consequence of this 2-week shutdown. So typically with these fixed price contracts, so the HIA one in particular, there'll be an entitlement to payment when stages become substantially complete. So if it is a situation where a builder is halfway through a particular stage, and Hamish mentioned this as an example before, so for example, the frames and trusses, it may be that some amount of the payment can be released to alleviate some of the difficulties that might otherwise flow on. But yeah, look, the key thing to do in these situations is to have a look at your contract, see what rights and obligations you have, and if you're in doubt, get some advice.
Yeah, and I think once you're clear on what you actually are entitled to do, that's when you're able to go and have a really meaningful conversation with the relevant parties. We certainly wouldn't be advocating for anyone to go and just throw in a claim right now in a relationship that is working well and that's going to be back on site hopefully in 2 weeks. We just know that obviously would end in dispute, but it's certainly something to go and have a conversation with the parties and see how you can either manipulate the payment schedule or the payment mechanisms to allow for some sort of cash flow to come out, including, it may be that the next cash flow you don't need until some point in August, but what you don't want to be able, you're still going to have to carry that lag of those couple of weeks. So you need to be getting your EOTs in, you need to be getting those claims in, but you need to work out a way. And I think the best way to do it with those owners and the banks and say, well, let's all take a little bit of the hit here, and let's move on. So and work out a way that we can all get back on site, get the works done, get paid. It may not be that you significantly increase the amount that is overall paid, but being able to manipulate the times of when you receive those is going to be very beneficial. So look at your contracts, talk to the advisors, and be collaborative with everyone that's involved.
I think one of the other things that's flowing on from that is when you're looking at, I think, claiming under the Security of Payment Act for the cost of delays and damages and things, there's a limit to how far you can go under the Security of Payment. So you really need to be making sure that if you're going to make a claim, it's one that arises under the contract, and in particular that impacts on the construction price as opposed to sort of a general claim for damages. So, in other words, if you have a clause of the contract that expressly says, in these circumstances, there'll be an entitlement to make a claim, and the construction price will be amended accordingly, you can be much more confident about making that claim under the SOP Act than if it's a more general claim that is arguably removed to some extent from the contract for sort of general damages. So again, there's some potential pitfalls there, but communication in the first instance, I think, is the key. And hopefully these things can be worked out, and there is some degree of cooperation until things can get back underway on the 31st of July.
Yeah, absolutely. We've got a question here from Tracy, which I'm just trying to open again. For an MBA cost plus contract, what clause do we refer to for an EOT for construction clause? I'm just going to pull up this one now, but I would say it'd be clause 13 if it's the same as the BC4, because I've got this one up in front of me, but we'll need to look at the cost plus one. Do you have it available in front of you?
I don't have it at my fingertips, no.
No. Okay, so it'd be most likely under clause 11, Tracy, but I could certainly have a look at that for you in the very near future. I was actually pulling it up. But those clauses, the MBA contract, and it's why we advocate for the MBA contract for a lot of our clients, is because it is so contractor friendly. And I know we've said that on a number of occasions, but because it is so contractor friendly, it does enable you to claim an EOT, and it does enable you to claim for the costs of those EOTs far more easily than almost all other contracts that are out there. So it's a matter of having a look at exactly what clause that is and inserting in there. It'd be in the clause called delay, and it'd be delay and commencement should be the name of the clause, and I would say it'd be clause 11. Here we go. I've actually found an example on our system, so I'll pull it up and I will let you know exactly what clause it is. It'll be clause 11, page 17. So clause 11, page 17, which will say, I can do this for you right now. Where are we? Yeah. Yep. So it's exactly the same as the BC4. So the delays and extension of time. There's a range of what they include. The 11A Roman numeral 12 would be the one that you'd be relying upon, which is any other cause, thing, or matter beyond the reasonable control of the builder, such as industry-wide trade or material shortages, which affect the builder's ability to do work. Now, don't worry about the such as industry-wide trade or material shortages, but what is clear is this shutdown is outside the control of the builder, which gives rise to the ability for you to claim an EOT. All right, look, if there are any other questions, please just send them through. Matt and I will hang online for about a couple of minutes. If there's nothing else, thank you very much for everyone for joining us. I hope you have a great day. Of course, there's a webinar on this afternoon at 2:00. So if you would like to jump into that, I believe Matt's presenting that as well with an insolvency practitioner, Chad Rapsey. So
tomorrow at 2.
Tomorrow at 2. Sorry, I'm jumping ahead. I'm thinking that's Thursday. But there is a webinar on this afternoon at 2:00 as well. So if you want further details, please reach out for any of the team. Matt and I will stay online for another couple of minutes. And if there's any questions, just please pop them in the Q&A. Otherwise, have a great day. Thank you.
Thanks, guys.